Welcome Monica Verma of Baker to talk about intellectual property protection, as especially many U.S. companies concerned about intellectual property theft in Asian countries and things like that. So Monica would address that.
So I don't have a PowerPoint presentation, but I can share a story going along with Monica's cultural differences issues. I do a lot of IT outsourcing projects, and one of my first ones I was doing, I was involved in the RFP process. This was the client's, one of the largest IT outsourcing that they were going to do. And in the meetings, I was the only person, from India, and of course the outsourcing was going to all happen in India. So a lot of information that I gave them, but they were still very concerned. Should we go? And I said, look, I can't help you with that. I can tell you what the issues are. I can help address them, but I'm not the one who's going to tell you if you should outsource to India or not. That's a decision you have to come up yourself. So based on those discussions and others, I asked them if they should go visit the places that they are going to outsource to and get comfortable. So they did the trip to India. Till at this point, they're very skeptical whether this is going to happen. All the stories, do you ride camels, do you have grass, all that stuff. They come back, of course, these are tier 1 providers, their facilities are better than some of the ones they've seen here. And the president of the company comes to pick up the client from the airport, takes them home, they have dinner. He takes half day off, takes them sightseeing. And then when the clients come back, they're like, that was great, where do we sign? And I'm like, no, we're not signing, now we're negotiating. But I think that cultural aspect of just that warmth or the hospitality, I think were meant so much to them that they were comfortable at that point that everything is going to go well. And then you have to help them understand that there are cultural, those are cultural things that is very normal in that part of the country. So again, as lawyers, we deal with a lot of contracts, but I think we have the added benefit, and I actually enjoy that part of my practice, is to help the clients understand that cultural landscape and the legal landscape in these different countries. So just focusing on the IP piece, the intellectual property, no matter what the structure of deal is, it doesn't matter if you are doing a distributor agreement, joint venture, whether you are outsourcing any of your IT functions, setting up your operations, intellectual property issues are always on the forefront. And most of the countries in Asia are continuously improving their systems. So of course there is always, from where we started, versus they all understand that there needs to be protection, there needs to be enforcement, so there's continuous improvement, which is great. And Japan, for example, it's rated pretty high with the enforcement and protection. They actually even have an IP high court where you can get very speedy recovery and judgments if there is any IP dispute. So great things. Now, I'm a big proponent when we look at any kind of strategy to do the diligence and plan ahead. And there is no substitute for that. So you could sign a perfect contract, but I think if you've done your diligence, you can do much better dealing with contracts. So it is just good to develop an IP strategy when you're looking at different markets outside of where your company is, if you're in the US and wanting to do business in any country outside. So first thing would be a great idea to do an internal audit of what IP you actually own, what categories does it fall into, and then review the local laws, treaties, and see what protection you can get in those countries. If it is available, it is great to register IP, and I will talk about this a little bit more. It's not necessary all the time, but always gives you added layers of protection. In some countries, it is necessary. And then take steps to protect IP, and those are simple things that you can do, is to train your employees in understanding how to protect information. Keep internal records, so when the time comes to prove that you actually own something, you have invention disclosure forms, you have dates that you can show when you started using a trademark. So all those things, just good internal policies. And limiting access, so if you have confidential information, limit access to employees who need to know. Their key employees, don't just share it out with everybody. And then when dealing with suppliers or distributors or business partners in other countries, and I think Nita mentioned a little bit on that issue, is you need to conduct comprehensive due diligence. Do reference checks, in-person meetings, visits to their facilities, do checks on court cases to see if they have been sued for third-party infringements. Was there any contract disputes? Things like that. I think they're always helpful to plan and you know what you're getting into. And then also when you're sharing information, again, internal communication is important as to how to share the information with third parties. Make sure there is right markings on it. If something you claim copyright, put a copyright notice. If you have a trademark that's registered, to put other people on notice, put the R with a circle on it. And then also, if something you claim to be confidential, at least put that notice on it. So that you're putting the other parties on notice that you're claiming some rights and it's on there. So, and then once we have all this diligence done and we move on to the contract terms, we talked about there's a lot of understanding. People say, I think they understand what I mean. Well, but when you start writing in the contract and you start thinking about those terms, people don't actually understand. So unless it's in a contract, it's not binding. So it's important to put terms that you really care about. And when we talk about, and I'll just kind of go over an example of a distributor and then a JV real quickly. So if you're dealing with a distributor, I have seen a lot of issues, and I still see them if it's not dealt with in a contract. You would put a licensing language, you have the right to do X, Y, and Z, but then you don't put any limitations on what they can't do. So a distributor in India, not that there is bad motives, but they just think, well, I should just go ahead and register this trademark in my name. That seems like a great idea. Or nowadays, domain name. It's very cheap, it's easy, they just register the domain name. And it may not become an issue while the contract is going well, but when the contract is not going well and you want to terminate, guess who has your trademark? The distributor sitting in one of the other countries. And it just becomes very expensive, and we talked about it takes a long time, and maybe that time we don't want to even be in that market. And so if we just address this issue early on, you may still have to go to the court, but at least there are terms in your favor that will help you. And even in cases like India, where it takes so long to get anything resolved, you can still get injunctive relief very quickly. So again, terms need to be clear. And joint ventures get even more complicated because parties are all, great friends. We want to do business, make money. So it is hard to talk about what happens when things go bad. And things do go bad. So it is important, again, talking about who owns what is being shared, who is licensing it, who's going to own it. If you're bringing in technology, there's a license agreement from one of the parties into the JV. Who is going to own intellectual property that is developed by the joint venture? So there could be modifications to an existing technology, there could be new technology, and there could be times when you would come up with a trademark that could be for selling the product. And then the question is, what happens if the joint venture terminates? Who will own the trademark? Who will own that modified technology? And the answers are not as simple as, look, we both can use it. Well, that's great in principle, but it doesn't work that way. So you could use the patents and technology and even the copyrights. Both parties can have equal rights, but when it comes to trademarks, you can't. So, example, you can only have one Apple company that sells iPhone. You cannot have two Apple companies selling iPhones, but you can have two Apples, one in the restaurant business and one selling iPhones. So it's important because when it comes to trademarks, it's not the rights of the company, it's avoiding consumer confusion. So that when I open that can of Coke, I know exactly what it tastes like. That's what you give to the consumer. So trademark has very strong value, and it is very important. So again, you cannot divide and say we both can use the same trademark, because you can't. So those are important issues. Maybe nobody can use it, maybe one can buy it, but again, these conversations need to happen when talking about trademarks. So just generally, I know with time I'm not going to go into details, but talked about different kinds of intellectual property when you're looking at, so we talked about trademarks, which is your brand name, then we have patents, copyrights, and I'll talk a little bit about confidential information. So trademarks, they protect your brand, as Rita mentioned, you go into a McDonald's, you know exactly what you're going to get, hopefully. When you take that bite into a Big Mac or whatever the Maharaja, yes, you know exactly what you're getting, and that's the power of brand. So there are ways to protect it. Of course, you can do a trademark application in the country where you are going to sell your products. And then there are a number of treaties, and for trademarks there is Madrid Protocol, where you can do a centralized application to cover a number of countries. You pay one fee. Again, there are pros and cons to it, which I'm not going to get too much into detail, but again, the applications can be managed at one central location. Now, trademarks, a lot of companies have gotten in trouble by not looking ahead as to the markets they are going into, because Japan and China are first to file. So even though a company could be using a trademark for, let's say, 10 years, but somebody else came in and made the application first, guess what? You lose your rights. So it is very important to think ahead and look at the marketplace, do the planning, and see which markets you need to be, because when people know, they pick up these big brand names first. So it is important to look in those countries which are first to file. Now, contrary to that, US and India are first to use. So it means whoever used first has priority and better rights. So if somebody files an application, you can challenge it based on the fact that you used it first. But even in those countries which have first to file, there are benefits for filing trademark applications. It puts people on notice. It deters others from using trademarks unlawfully, and then, of course, you can file infringement lawsuits if that issue comes up. So moving on to patents, which they grant a person an exclusive right to market, sell, and use a technology and invention. And it is pretty much the same in all the countries, but the filings, I think we get a lot of benefits from a number of treaties that are in place. So always you can do a national filing to claim that priority, to give you that exclusive time frame. But then there is Paris Convention, which again, most of the countries, including US, India, China, Japan, are parties to. And what it gives you is a right of priority that once a patent application is filed, let's say, take an example here in the US, you get 12 months to file a patent application in another member state, and you get priority from the date of filing. So that's great to use that Paris Convention, but also what it does is if you don't file it within that year, you do lose the rights to file the patent and get that exclusive right in the country. So again, important planning based on once you file a patent application, look at the market, and we had a case that actually I'm dealing with right now where we talked to the client and they thought, what technology, just US and Canada would be great. Of course, expense, they were a smaller company, and guess what? They called me just last week and said, hey, we have somebody in France interested. How do we file a patent? I'm like, sorry, you can't file a patent. But there are ways that you can do other things. Of course, we came up with recommendation that, of course, they can always do a confidentiality agreement because there's more to it than just the patent. But, nobody likes to hear it, but that's the hard thing, that if you lose it, you just can't do anything. The other treaty I briefly want to just mention is a patent cooperation treaty, and again, most countries, including everyone I mentioned before, is a member. And what that does is, again, gives you a central filing system where you can designate all the member countries to be part of that application, and that gives you additional 30 months to convert that application. So again, if you're looking at partnerships, funding, markets, that's just as part of the strategy can be looked at to say, we file an application, let's designate all these other countries while we're looking, because after that 30 months pass, you can decide not to do anything and just get out of those applications. But again, good idea to just plan ahead and see what can be done. Now, copyrights are different than, so everything that you create, including all the PowerPoint presentations that we have here today, everything, the moment it's created, there's a copyright in it, and it's protected at the moment it's created. And all the countries pretty much follow that rule. And I think you mentioned the WIPO,
Yeah.
the copyright treaty, and that's part of the Berne Convention, that protects any work created in one member country and gives protection in every country from the time it's created. So that's great. And again, you don't need to have copyright registrations, but again, a good way to put others on notice. Also, in most countries, you need to have a copyright registration to bring action against a third party. So even if you've not done it, you have to do it before you file an action. And I think software code is another one that is part of the copyright. So when you look at all these materials, it's not just paper. Most of the code under software or any kind of website, everything is protected under copyright because most patent jurisdictions do not grant a lot of process applications for patents for software. And last, real quick on the trade secrets and confidential information. Again, those are protected by statutes. The best process for them is keep them confidential, disclose them when necessary, only through NDAs, so you have that in place. And again, most jurisdictions, I think in India it's called breach of trust claim.
Yes.
That you can, yes, so there's, you can get injunctive relief, and to me, in some cases, yes, you may not get a whole lot of damages in certain jurisdictions as you may here in the US. But at that point, it's more important to stop the bleeding and stop the use of that confidential information. So there are remedies and enforcement options available. So again, important to have these confidentiality agreements in place before you disclose any information that you think is confidential. Then hopefully, the burden is on proving it. But at least if you don't have an NDA, there is no confidentiality unless you protected information. So in short, again, it's important to plan ahead. And in today's time, when I talk to the clients, I always talk about the global market. And it's getting smaller and smaller. The middle class in some of the Asian countries is getting larger, and a really good market to sell products. So when you are thinking about a market, I know cost is an issue, but it's cheaper to file and protect yourself up front than to go in and try to either get that trademark from somebody else or enforce your rights. So again, it's just part of that process. So no substitute for doing the diligence and